promissory note or mortgage that calls the entire amount of the unpaid loan balance due upon the happening of a certain event is known as a blank clause. A, inchoate clause. B, acceleration clause. D, indemnification clause, or I mean C, indemnification clause, or D, habedim clause.
B.
B, that is correct. And so I'm gonna copy and paste put this in the chat regarding the explanation of, okay, cool, the answer, but an acceleration clause is going to be the correct answer because that's when you make the entire payment at the end. Okay. And disintermediation refers to A, the movement of money out of savings account into a higher yield investment. B, representing both parties to a transaction. C, transferring real property by a private owner to a public agency. Or D, an instrument used in many states in place of a mortgage. This is a tough one because they don't mention this often in your classes. So it's like one of those newish vocab words that they throw at you. But anyone want to take a guess? Feel free to say it out loud or in the chat. Either way. Disintermediation. Any guesses?
No, I'll just guess A.
Okay, that's good guess. Yeah. And you're correct.
Wow.
So, right, like sometimes with these questions too, like if you don't know it and you can't even think of it, and even if like put it in context, a lot of the times the longer the answer is the correct answer. But yeah, so I'll put the question in here. So a deed of trust is an instrument used in many states in place of a mortgage. Dedication is the transfer of real property by a private owner to a public agency. Disintermediation is the movement of money out of a savings account into a higher yield investment. And then dual agency is the act of representing both parties of a transaction. So they kind of threw that representing both parties of a transaction in there to fool you. Okay, next one. An investor decides to take money out of a savings account and invest it in a high return corporate securities. This movement of money is known as
No, just A.
Yeah, it was the last question. The movement of money out of a savings account into a higher yield investment. I'll put that in the chat. All right, next question. An additional loan fee charged by lenders to make the yield on lower than market interest rate loans competitive with higher interest conventional loans is called A, a discount point, B, disintermediation, C, debt, or D, debt service. And correct.
Ooh.
A is it's a discount point. As we said, the disintermediation is the movement of money out of a savings account into higher yield investments. Debt service is the amount of money paid in regular intervals to reduce the balance due on a debt. A debt is the amount of money owed. And then a discount point is an additional loan fee charged by lenders to make the yield on lower than market interest rate loans competitive with higher interest conventional loans. Now you guys will remember disintermediation like no other. Okay. Cool. So a buyer is late with his monthly mortgage payment. The lender could declare the entire unpaid loan amount due immediately under which clause? A, hypothecation, B, acknowledgement, C, acceleration, or D, accretion. Oh, right. So we did have this one earlier, and that's gonna be
C.
yeah. Good call. So the first one, here we go, is gonna be refers to the pledge of property as security for a collateral on a loan. The term accretion refers to the gradual addition of soil to property by natural causes. So it's the opposite of erosion. So again, they threw that in there, but that has nothing to do with mortgage. Acknowledgement is a person signing a document and formally declaring to an authorized official that he signed voluntarily. The official then certifies the signature and voluntary and genuine, and the acceleration clause makes the entire loan amount due upon happening of a certain event. Just like this when he missed the payment. All right. The provision on a promissory note or mortgage that calls the entire amount, oh gosh, we just had this, unpaid loan balance due upon the happening of a certain event is known as a blank clause. Gosh, they keep asking us about the same thing. We all know that's going to be acceleration. I think I already put this in the chat, but I'll put this in the chat again, explaining. Oh, you know what? I accidentally tapped out of the quiz, so it probably just okay. A lender charges 3 discount points on a loan. The buyer is buying a $100,000 home and is getting an 80% mortgage. How much in discount points would the borrower be required to pay? So 80% mortgage, 100,000. Okay. Well, let's just, we have A. That is correct. And the math behind that is, I'll put this in the chat as well. So each discount point is going to be 1%. So with 3 discount points, that's 3%, and you would do 3% on the loan amount, which is 80% of 100,000. So it would be 80,000 times 3%, which would then equal 2,400. Okay. A lender wishes to make the yield on a lower than market interest rate loan competitive with higher interest conventional loans. What would the lender charge in order to make the loan more competitive? A, discount points, B, debt service, C, deed in lieu of foreclosure, or D, penalty points. So this is what would the lender charge in order to make the loan more competitive?
A.
A?
Mhm.
Okay. Correct. So discount points, you're getting basically this is making it more competitive. It's more enticing to the person obtaining the loan. Charged by a lender to make it lower than market loan, more competitive with higher conventional loans. A homeowner's property has been foreclosed upon by the bank and sold at public auction. The homeowner owed $50,000 on the mortgage, but the property sold for $40,000. To collect the $10,000, the lender could A, ask for dedication, B, file a deed of trust, C, obtain a deficiency judgment, or D, file a deed in lieu of foreclosure. So in your answers, they're throwing a lot of vocab words at you. Which one? Okay, we got C. Correct. A deficiency judgment is the mortgage debt that remains due and payable by the borrower after the share or sale of property. The judgment is actually for a full amount of the unpaid mortgage debt. By the foreclosure sale, proceeds are deducted from the amount due. Dedication refers to the transferring of real property by a private owner to a public agency. Deed in lieu of foreclosure is the agreement that the mortgagor will grant title to the mortgagee so that the mortgage will not file for foreclosure. A deed of trust is an instrument held by a third party as security of the payment of a note. So again, just the various definitions of each one kind of helps you do process of elimination. And this I know for sure is going to be on the exam. So definitely revamping your vocab and just like this, seeing how they put them into questions is super helpful. Sally and George, a married couple, have elected to buy a home. Their calculated PITI is well within the qualifying housing ratio percentage. What does PITI stand for? A, principal, interest owed, taxes, and income. B, percentage of loan amount, interest, total annual income, insurance. C, principal, interest, taxes, insurance, or D, principal, income, total debt service, interest.
Yeah, C.
C, right. And that is correct. So the PITI stands for principal, interest, taxes, and insurance. Monthly mortgage obligations includes monthly mortgage payment, property taxes, and insurance. And this, again, this one is also on the exam, I remember. A type of financing available for real estate mortgages is in which the percentage interest rate will differ from year to year according to terms specified by the lender is known as A, fluctuating loan, B, fixed rate loan, C, adjustable rate mortgage, or D, amortized loan. Amortized loan. Okay, B. All right. Good job, guys. Amorization, I cannot ever say this word, refers to the method of paying off a loan with varying amounts of principal interest each month, although the interest rate may stay the same. By definition, the percentage rate of adjustable rate mortgages varies. Fixed rate mortgages are those in which the annual percentage rate never changes, and a fluctuating loan is not an actual loan, but a description of a loan's characteristics. So the first one is not even a vocab word. They're just, or even a thing. They're just throwing that in there because loans can fluctuate, so they just create a loan. All right. Good job, guys. We got 100% on that. Okay. What other topics would you like to do? We can do another financing, or we could switch it up. These are all various ones. I know last week we did leasing and property management. We did practice of real estate. Anyone have anything they want to?
Do you have a specific section on the state questions?
Um, like, is there a specific section on state questions?
Well, there is on the test.
Yes. Mm-hmm.
Can you do a section
Oh yeah.
that,
That is going to be state related. Yeah,
yes,
that's a good one. Yes, and you know what? This one, license law and rules of the Ohio Real Estate Commission. This is actually a perfect one to do
good.
because I do know that there are various questions about that. Perfect. Yeah, let's pop in here. Who approves the appointment of the ancillary trustee when a broker has died? So is that gonna be A, probate court, B, debt of commerce, C, division, or D, commission? So who approves the appointment of the ancillary
Probably B would be the only, to me,
Department of Commerce?
yeah. Oh, or A.
All right, so probate court, so like, an estate, probate court also comes in play, so the appointment has to go through probate court to then go to the court of jurisdiction over the estate. Yeah, I feel like they tricked you because it's like, they're talking about division commission, but don't even like explain Department of Division or Commission. And then, since we're in the topic of license law and rules of Ohio Real Estate Commission, the Department of Commerce sounds ideal, but when it comes to like trustees and like of a person dying, they do have to go through probate court. All right, broker X is managing a client's 5-unit apartment complex. The broker receives rent deposits of $100 for each unit. What must the broker do with the rent deposit receipts? A, deposit them in the broker's trust account. B, deposit them in the property management account in the client's name. C, deposit them in the office management account. Or D, commingle the funds with the trust account fund.
Maybe A.
A? Okay. It's actually B. This is a tricky one. So
Hmm.
let's see. By law, broker must deposit all rent receipts and rent deposits in a property management account and not in the broker's trust account. Depositing these monies in the broker's trust account would be considered commingling or mixing of funds. And then commingling is an unethical act. So how they trick, basically this one was tricky with the Lions 5-unit apartment complex. Then we get into property management, which then becomes where you would use the property management account and not the broker's trust account. And I'll put this explanation in. That was a hard one. I was gonna say C, so that would have been. Under Ohio law, every listing agency agreement must have A, a mandatory extension clause, B, a statement defining the practice known as blockbusting and stating that it is illegal, C, the company policy for brokerage and dual agency, or D, the diversity in housing logo. All right, let's do C. And actually, it is B, which is also very tricky when they do this because we do talk about both the company policy for brokerage and dual agency, as well as the diversity in housing logo goes in there. But when it's every listing agency agreement, so the key word here is listing agency agreement, they must have the blockbusting clause in there. And a statement is, oh, so under section, you don't, so where it says 473.55, you don't need to know any of that. But each written agency agreement shall contain an expiration date and a statement that it is illegal to refuse to sell, transfer, or rent property because of a person's race, color, etc. A statement about blockbusting must also be contained in the listing. Okay. A real estate agent listed a property that was vacant. The agent ran a machine to make the rooms smell good to cover the odor of animal waste. Is the agent obligated to disclose? Is the agent obligated to disclose that if not for the machine, the rooms would smell bad? A, no, the agent must only tell the selling broker. B, if the odor would remain after the machine is removed, then the buyer must be told of the pet damage. C, caveat emptor says that it is the buyer's problem. Or D, no, but the agent must never remove the machine. This is kind of tricky, isn't it? So that means buyers beware. Says that, so basically they're saying that's the buyer's problem. But any guesses? C? I honestly also would have chose C, but it actually would be B because the order remain after the machine is removed, then the buyer must be told of the pet damages. So even if the buyer at the time didn't smell the odor, they go back in and do, then that would have to be disclosed. But honestly, no machine could really get rid of specific odors, but only if they had something that to come in to completely remove it and not just like a candle lit, or I'm not even sure what type of machine they would have in there. So this is a tricky one, and it gets like specific with um how they word the question. So if the agent is aware of a hidden defect, he or she must disclose the defect to all interested buyers, even if the property is vacant. It's a tough one. I feel like they didn't word that better. A homeowner is selling his house without the aid of a broker. The homeowner advertises that he will give anyone who buys his home 2 free airline tickets to anywhere in the continental United States. What is true? A, this is perfectly legitimate and does not need to be disclosed on the sales contract. B, this inducement must be disclosed on the sales contract. C, the inducement is in violation of the Ohio Revised Code licensing law. Or D, a seller is not authorized to give an inducement of any manner to an unrepresented buyer. Right, do it. And A is correct. Ohio, good one. This one sounds tricky because you're like, how is that? Okay, but Ohio licensing law states that a broker or sales agent must disclose in a contract any additional considerations that are inducement. Since there is no sales agent or broker involved here, no disclosure is necessary on behalf of the homeowner. Questions like this always trip me up during the exam. But yes, just reading and kind of rereading the question if you're like for process of elimination and being like, first time you read it, you didn't catch that no agent is involved. So you're like, oh wait, no agent's involved, so everything's fine. You don't have to disclose anything. Good job. The rate of commission for residential properties is set by the A, Ohio Real Estate Commission, B, broker and the principal, C, multiple listing group, or D, Ohio Real Estate Board. D, broker and the principal is correct. The rate of commission for residential and commercial sales is not set by law, but is completely negotiable between the broker and the seller, which is also principal. Well, I'm sorry, and I could hover over these to explain them further. So commission, a 5-member committee that can adopt, amend, or rescind regulations concerning real estate licensing. So 5-member committee. All right. Under Ohio law, a non-licensed employee of a property manager may A, explain the difference between a periodic tenancy and a month-to-month tenancy. B, accept payments of a pre-negotiated rent from a tenant each month. C, negotiate a lease between the landlord and a potential tenant. Or D, prepare the lease agreement for the landlord and tenant. So under Ohio law, a non-licensed employee of a property management may. Right. B, C. Correct. A non-licensed individual working for a property manager may accept rent, show the property, and have a tenant sign a pre-prepared lease agreement. The unlicensed person is not authorized to prepare a lease, but may offer for a signature of a pre-prepared lease. All right. Upon the death of a licensed broker, what might occur? A broker within the business entity of the deceased broker takes over the listing. B, the Ohio Real Estate Commission appoints an ancillary trustee. C, the superintendent appoints an ancillary trustee. I don't know if I'm saying this word. Or D, the sales agent takes over the broker's listing. So upon the death of a licensed broker, what might occur? Right. Well, this one is also tricky, but it would be A. So a broker within the business entity of the deceased broker takes over the listing. If a broker dies and there is another broker in the business entity, then the broker may take over the listings without the appointment of an ancillary trustee. If there is no other broker in the business, then the ancillary trustee would have to be approved by the probate court. So they're trying to trick you with this, but they're like assuming that there's another broker available to take the listings, then that would happen. But if there wasn't, then that's when probate court becomes involved. All right. A seller tells the listing agent that her home was treated for termites a decade ago. Before listing the property, the agent should A, talk to the neighbors, B, tell the seller to disclose the old infestation, C, tell the seller not to disclose the infestation as it was longer than 5 years ago, or D, talk to planning and zoning. Hmm, are we thinking? B? That is correct. If you are presented with the choice of tell the seller to disclose and tell the buyer or buyer's agent, your correct choice would be tell the buyer. It wasn't one of your choices, tell the seller to disclose becomes the best answer. You were presented with a choice of tell the seller to disclose and tell the buyer or buyer's agent. It would be tell the buyer. Oh, interesting. So the best answer would be to tell the buyer in this situation. But seeing that it wasn't one of the choices, tell the seller to disclose becomes the best answer. Okay. A licensed property manager is negotiating a lease on behalf of a commercial landlord. The property to be rented is retail space in a soon to open mall. What type of lease would you expect the property manager to negotiate? A, a net lease, B, a gross lease, C, a land lease, or D, a percentage lease?
D.
D? That is correct. Good job. A percentage lease is usually used in retail establishments with the rent based upon a percentage of the sales that the tenant makes each month. A gross lease is usually found in an apartment setting, and a net lease is usually found in heavy industrial settings with the tenant paying rent plus taxes, utilities, and insurance. A land lease usually involves farmland. This is super helpful description. So when you do get questions like this, you can kind of be like land lease is for farmland and net lease, you pay for rent, taxes, utilities, and insurance. Gross lease is kind of found in like an apartment setting. So a question about apartment, and then commercial setting and retail is going to be that percentage lease. Okay. An agent told the buyer that they would have the option of tapping into the new sewer when in fact tapping into the sewer was mandatory. The agent's action violates A, federal law, B, license law, C, tax, force on agency, or D, code of ethics. Agent told that they would have the option of tapping into the new sewer when in fact tapping into the new sewer was mandatory. Agent's action violates. What are we thinking? Let's try D. Nope, license law. Actually, I have no idea what prohibits knowingly making misrepresentation. Ohio Revised Code prohibits knowingly making misrepresentation. Honestly, this one's tricky because we didn't know that the agent knew that tapping into the new sewer was in fact mandatory. But assuming that the agent did know and told them that they had the option, it would violate the license law. Oh, that's like a poorly written question. All right. Who can be affected by lead poisoning? A, children, B, anyone, C, elderly, D, pregnant women.
B.
Okay. Correct. Anyone can be affected by lead. Teething toddlers by eating paint chips. Anyone breathing in lead when standing walls. All right. If a broker dies and there are no other brokers in the firm, what is true? A, the superintendent may appoint an auxiliary trustee with the approval of probate court. B, the Ohio Real Estate Commission may appoint an auxiliary trustee. C, A salesperson associated with the firm may take over the deceased broker's listings. Or D, the Department of Commerce will appoint an ancillary trustee. So in the previous description, all right, we're gonna try B. It's actually A. So if a broker dies and there was no other brokers in the firm, the superintendent may appoint a salary trustee after they have approval from the probate court. So in event of broker's death, the superintendent, with the approval of the appropriate probate court, may and appoint an auxiliary trustee. If a broker's license is revoked, then the superintendent may appoint a auxiliary trustee with the approval of the Ohio Real Estate Commission. Interesting. They put another scenario in here about the broker that died. So if their license was revoked, then the superintendent would appoint the auxiliary trustee but need approval from the Ohio Real Estate Commission. But being that this broker's license isn't revoked and they didn't mention anything about that, they would need the approval of probate court. All right, John, a real estate agent, has been found guilty of violating the Federal Fair Housing Act for the third time. What most likely will occur? A, the commission will revoke John's license. B, the commission will suspend John's license. C, John will be fined a minimum of $2,500. Or D, John's license will be suspended for 2 months. These are hard, the various violations that you have to go over. All right, C. Oh shoot, I would have chose C too. The commission will revoke John's license. Right, the key one is going to be the third time. If this were John's first offense, then the commission might suspend John's license. If this were a second offense, then the commission would either have suspended John's license for 2 months or permanently revoke John's license. But since it's his third offense, the commission must revoke the license permanently. There is no minimum fine that the commission must levy against any sales agent or broker. Oh, interesting. A broker loses her license and there is no licensed broker to take over the broker's business. In this case, an ancillary trustee must be appointed by the superintendent to conclude the broker's business. The sales agent may take over the listing. The sales agent may take over only those listings that are in contract, or the probate court must approve the appointment of the ancillary trustee.
A.
A is good job. So there's no one died, so we don't need to involve probate court. The probate court must approve the appointment of a ancillary trustee only in the event of a death of a broker. Otherwise, the superintendent has the power to appoint a ancillary trustee. A sales agent would be allowed to take over the broker's listings only if appointed as the ancillary trustee. Really should probably look up how to say that word. What type of property is encompassed by Ohio's broker lien law? A, 4-family apartment complex. B, single-family residence. C, vacant property zoned residential. Or D, commercial property. And a lien is going to be a non-possessory interest in property, giving a lien holder the right to foreclose if the owner does not pay a debt owed the lien holder. A financial encompass on the owner's title. Financial encumbrance on the owner's title. Any guesses? So what type of property is encompassed by Ohio's broker lien law? Going to be, I was actually gonna guess B as well, so it's gonna be commercial property. Ohio's broker lien law covers commercial property only. A broker may file a lien for unpaid commission against commercial property, but not against residential property. Did not know this. Hmm. This is probably gonna be like one of the only commercial questions you'll, hopefully only one of the commercial questions besides like the rent and things that you'll get. But that's good to know. All right. What would you expect an Ohio property manager to do? A, convert the apartments into condominiums for the landlord. B, initiate actions for the recovery of rent. C, prepare a land contract in case the landlord wanted to sell the property to a tenant. Or D, prepare lease agreements for tenants to sign. So what would you expect an Ohio property manager to do? B? That is correct. The property manager may initiate action for the recovery of rent on behalf of the landlord. The other answers are all involve unpracticed or unauthorized practice of law. The commission shall suspend for a minimum of 2 months or revoke the license of any broker or sales agent found guilty of A, second fair housing violation offense, B, third fair housing violation offense, C, fourth fair housing violation offense, or D, first fair housing violation offense. So the commission shall suspend for a minimum of 2 months or revoke the license of any broker or sales agent found guilty of A second. That is correct. The commission must, as a minimum, take the action for a second fair housing violation offense. And this is as a minimum. Take the action of revoking or suspending their license for 2 months and or revoking it. Okay. When would a license be considered inactive? A, when the salesperson fails to turn in proof of CE. B, when the salesperson directs the broker to return the license to the division. C, when the salesperson does not have a transaction within the mandated period of time. Or D, when the broker dies. So tricky. This is a tricky one, but what do you think? D? Oh, I was gonna say D too. When the salesperson directs the broker to return the license to the division. Inactive is a voluntary status that is initiated by a salesperson or broker. Failure to turn in proof of CE may result in license being suspended. Let's know. I'm not sure what the status would be if a broker passed away, but knowing that inactive is a voluntary status that the salesperson asked for the broker to do. So you can always put your license as inactive, and then when you're ready to reactivate or get back into real estate, you could reactivate your license. An agent receives an earnest money deposit check of $1,500. It would be considered commingling of funds if the agent A deposited the check in the broker's trust account, B held the check until closing, C placed the check in his commercial checking account, or D turned the check over to the seller.
C.
C. Correct. So commingling of funds means a mixing of earnest money accounts and other funds. So commingling is when you literally mix your personal bank account or any accounts with your business, like with transactions. Holding the check until closing may be a violation of a law as well, but it is not commingling. It may be considered conversion or theft. Oh, well. Well, that was a lot of questions. I'm glad we went over that. Was super helpful stuff to know for the exam. And for the remaining time, anything else that we guys are thinking? Want to go over? Need a little refresher on? There's topic. Let's do general principles of agency. Once established through a listing agreement, what fiduciary duty does not ever end? A, financing, B, confidentiality, C, obedience, or D, loyalty. Fiduciary is person in position of trust held by law to high standards of good faith and loyalty. What are we thinking?
Maybe B.
B, confidentiality. Correct. The fiduciary duties of an agent are the duties of accountability, care, obedience, loyalty, and disclosure. While these duties are important, the duty of confidentiality never ends. After the closing, the duties of obedience and loyalty terminate. There is no duty of financing. Great question. They try to trick you by using the word fiduciary duty, but because of the acronyms they give you, but confidentiality, the duty of confidentiality never ends. S&T Realty had a listing on a property. After the property sold and closed, P&M Realty asserted its rightful claim to the commission. Which type of listing did P&M Realty have? A, net listing, B, exclusive right to sell listing, C, open listing, or D, exclusive listing. Open listing. Okay, that is correct. Only the procuring broker is entitled to the commission in an open listing. If the seller finds the buyer an exclusive agency listing, he owes no commission. In exclusive right to sell listing, the listing broker gets paid the commission no matter who sells the property. A net listing means the broker receives whatever is left over after the seller gets the predetermined net amount. So they give you all of these so you have an idea of what they are, but you will always be using the exclusive right to sell listing. Which is the best example of a general agent? A, property manager, B, universal power of attorney, C, power of attorney given specifically to transfer an automobile, or D, real estate agent. Best example of a general agent. Thank you. It's going to be A. And so A universal agent is one who may do anything for the principal, while a general agent may do anything in one specific area, like property management. So a real estate agent is considered a special agent, having the authority to do only one thing for the principal, just like the person given the power of attorney to transfer an automobile. So this was tricky too, because they kind of give similar ones, like a special agent and a power of attorney. This is like a specific thing they have to do. Real estate, there's a specific thing you do, but property management, the specific area that you do. So that was hard. Definitely, I would recommend knowing like a general agent equals property manager or property management, kind of like making vocab similar to that, because on the test they use the terms like they don't just use property manager, they sometimes use general agent. Like they use whatever they also like for principal and client, just so you know, like one in the same. The AKA, also known as, is super helpful, and that would definitely help you on the exam. A sales agent has a duty to treat all parties to a transaction honestly and fairly. A, only when representing a buyer in transaction. B, only when representing a seller in transaction. C, in all transactions. Or D, only when acting as a dual agent.
C.
Correct. Even with a customer, an agent has to be fair and honest. With a client, the agent has even more duties, are those fiduciary duties. Okay. A licensee has secured their first listing contract. The licensee most likely is considered a blank agent. An A, special agent, B, limited agent, C, general agent, or D, universal agent. And A is correct. So a special agent is committed to doing one thing for a client. Example, marketing the home. A universal agent must do everything for someone. Example is a guardian. A general agent does more than one thing, but not everything for a client, which is a property manager. And then there's no such thing as a limited agent. An agency relationship created through a listing contract can be terminated legally without recourse under which circumstance? A, when the salesperson becomes mentally incompetent. B, when the listing broker dies. C, when the buyer dies. Or D, when the listing salesperson dies. Agency relationship of trust created when one person, the principal, gives another person, the agent, the right to represent the principal in dealings with the third party. B, and that is correct. The listing broker is the agent of record in a listing. A listing is an employment agreement, therefore when an employee dies, the agreement is void. This is not the salesperson's listing. The listing belongs to the broker of record in every transaction, not the agent. So even as a licensed agent, you work under a broker. So when you do list a property, although it would be you're the agent, it's your listing, it is still under your broker in your brokerage. Okay. Which is the best example of a special agent? A, real estate licensee, B, universal power of attorney, C, limited agent, or D, property manager. All right, correct. Cool. Now we'll never forget that real estate licensee is a special agent. So you guys will soon be special agents. Okay. Brandon lists a property. Brandon finds a buyer. Is Brandon allowed to write an offer as a buyer's representative? A, yes, as long as both parties agree to it in writing. B, no, an agent cannot collect both commissions. C, no, it's against federal trade laws. Or D, yes, if it's specifically written in the offer. That's kind of- What are we thinking? Okay, that is correct. Informed consent is required to have disclosed dual agency. Getting everything in writing is key. And both getting everything in writing is key, and obviously having both initials and signatures by what is in writing. So if something was changed in a contract, always making sure that both parties know of the change and initial by it. Okay. A listing broker tells their buyer client that the seller is anxious to sell because they are delinquent in their mortgage payments and do not want the property to go into foreclosure. Such a disclosure is A, only permitted if the mortgage lender authorized the disclosure, B, acceptable if it results in an offer and quick sale of the property, C, required because the broker is also the agent of the buyer, or D, unacceptable because of the fiduciary duty owed to the seller.
D.
Correct. The fact that the property owner is delinquent is information considered confidential under an agent's fiduciary duty. It cannot be revealed without consent. The broker acting as dual agent is bound to limit confidentiality, and the lender has no interest in the property until foreclosure action is actually undertaken. Yeah. All right. So yes, good job. Yeah, they try to trick you in that, but reading through it and knowing that you have to keep everything confidential, and in order to like say anything to any other agent or seller, you need your client's permission to do so. So basically their consent to do so. All right. Which of the following factors would be most significant in deciding whether a broker was acting as a buyer's agent? A, the broker assisted the buyer in securing financing for the property being purchased. B, the broker showed the buyer properties listed by cooperating brokers. D, the buyer signed an exclusive representation agreement with the broker. Or D, the buyer paid a commission to the broker. D, is correct. An exclusive representation agreement would be evidence of a principal-agent relationship. Compensation is not a determining factor, and brokers may cooperate as subagents if permitted when showing property. Assisting in securing financing does not create an agency relationship. All All right, good job, guys. Cool. Well, thanks so much for participating. Hopefully this was helpful for everyone.
Super helpful. Thank you.
Oh, good. Yes. Yes, for sure. Thanks so much for participating.